Let's be brutally honest for a moment. That feeling of relief when you finally find a tenant for your property. It can vanish overnight if you're relying on a vague text message agreement, a handshake, or worse, a free, generic lease template you downloaded from the internet. That document isn't just a formality, it's the single most important piece of paper in your landlord-tenant relationship. It is the rulebook, the contingency plan, and your primary line of legal defense all in one. A poorly written lease leaves you exposed to endless disputes over repairs, unauthorized occupants, unpaid rent, and nightmare scenarios like property damage or illegal activity. But a well-crafted, comprehensive rental agreement does the opposite. It establishes crystal clear expectations, minimizes misunderstandings, and gives you a solid legal footing if things go south. This isn't about being overly strict or adversarial. It's about being professional and protecting the significant investment you've made in your property. In this guide, we're going to move beyond basic templates and walk through the construction of a bulletproof rental contract. We'll dissect the essential clauses that most amateurs miss, explain the legal reasoning behind each one, and show you how to tailor it to your specific property and local laws. By the end, you lines understand that a great lease isn't a barrier to a good relationship, it's the foundation for one. We must start with the non-negotiable foundation, local and state law compliance. Your lease is not a standalone document. It exists within the framework of your city, county, and state's landlord-tenant laws. A clause that violates these laws is not just unenforceable, it can get you sued and fined. For example, some states have strict limits on how much you can charge for a security deposit, often 1 or 2 months' rent, and dictate exactly how and when you must return it. Many cities have specific just cause eviction ordinances or rent control statutes that override anything you put in your lease. Some jurisdictions require specific language about lead paint, mold, or tenant rights pamphlets to be included verbatim. The very first step before you type a single word of your lease is to research. Check your state's Landlord-Tenant Act online and look up your city's housing department website. Better yet, consult with a local real estate attorney who specializes in landlord-tenant law. Paying for an hour of their time to review your final draft is the best insurance policy you can buy. The common, catastrophic mistake is assuming a national template covers you. It doesn't. Your lease must be custom-built for your legal jurisdiction. With that legal foundation in place, let's build the core identifying sections. These seem basic, but ambiguity here is poison. Parties. Use full legal names. If you own the property in an LLC, which you should for liability reasons, the landlord is the LLC, not you personally. The tenant should be every adult who will reside in the unit. This makes each one jointly and severally liable, meaning you can pursue any one of them for the full rent or damages if the others disappear. Property description. Don't just list the address. Specify the exact premises being rented. The single-family home located at 123 Main Street, including the attached garage and fenced backyard, but excluding the storage shed. For a multi-unit building, specify the unit number, assigned parking spot S, and any storage locker. Lease term. Clearly state the start and end date. Then, you have a critical choice. Will it be a fixed-term lease that converts to month, or a strict fixed term that requires renewal? The pro tip is to include an automatic conversion clause. At the end of the initial 12-month term, this lease shall automatically convert to a month-to-month tenancy under the same terms unless either party provides written notice of non-renewal at least 60 days prior to the end of the term. This prevents a holdover tenant situation and gives you predictable control. Now we get into the operational heart of the lease, the financial clauses. Rent. State the exact monthly amount, the due date, for example, the first of each month, the acceptable payment methods, check, bank transfer, etc. And, crucially, the physical address or portal where rent must be delivered. This defeats the "I mailed it" excuse. Late fees. This clause must be reasonable and comply with state law. Don't just say a late fee will apply, specify the grace period, if any, as some states don't allow them, the exact fee amount, for example, $50 or 5% of the monthly rent, whichever is greater, and the date it accrues, for example, on the 6th of the month. A powerful, often overlooked addition is a clause for returned payment fees to cover bank charges. Security deposit. Detail the exact amount, the bank where it will be held. Some states require separate, interest-bearing accounts, and a specific list of the allowable deductions beyond just damage. This should include unpaid rent, late fees, cleaning costs to return the unit to its original condition, and the cost of repairing damage beyond normal wear and tear. Reference your state's required timeline for providing an itemized deduction statement after move-out. The maintenance and repair section is where most landlord-tenant wars begin. You must define responsibility with surgical precision. Start with a clause requiring the tenant to promptly report all maintenance issues, especially water leaks, to minimize damage. Then, create a clear split. Typically, the landlord is responsible for the structure and major systems: roof, exterior walls, foundation, plumbing, electrical, and HVAC systems. The tenant is responsible for minor maintenance and daily upkeep, replacing light bulbs, air filters, battery and smoke detectors, and keeping drains clear of hair and grease. For landscaping, specify who mows the lawn, waters, and shovels snow. The insider strategy is to include a specific dollar amount threshold, like tenant is responsible for the first $100 of repair cost for any service call that is necessitated by tenant misuse or negligence, such as a clogged drain or locked-out unit. This discourages frivolous maintenance calls. Absolutely include a clause prohibiting unauthorized alterations. Tenant shall not paint, install shelves, or make any alterations to the premises without the landlord's prior written consent. Now, let's address the clauses that prevent the most common problematic scenarios. Occupancy policy. Explicitly state that only the individuals named on the lease and their minor children may reside in the unit. Specify that guests may not stay for more than 14 consecutive days or 30 total days in a year without written permission. This prevents unauthorized subletting or de facto additional tenants. Pet policy. If you allow pets, never rely on a verbal agreement. Use a separate pet addendum. It should list the approved animal by breed, weight, and name, require proof of vaccinations and license, mandate spaying, neutering, and establish a non-refundable pet fee or a monthly pet rent. It must also hold the tenant fully liable for all damage or nuisance caused by the animal. Subletting and assignment clearly state that the tenant may not sublet the unit or assign the lease without the landlord as prior written consent, which may be withheld at the landlord's sole discretion. This gives you control over who lives in your property. Right of entry. You have a legal right to enter for repairs, inspections, or showings, but you must provide proper notice as required by state law, usually 24 to 48 hours. Your lease should state this notice period and specify that entry will be during reasonable business hours except in emergencies. The conclusion of the lease needs to cover the beginning and the end. The move-in, move-out inspection process is critical. The lease should mandate that both parties complete a detailed condition checklist at the start of the tenancy, documenting the state of every wall, floor, appliance, and fixture, supported by date-stamped photos or video. Both parties sign it. This is your only objective evidence to dispute damage claims later. Finally, the default and remedies section. This outlines what constitutes a breach: non-payment of rent, violation of lease terms, illegal activity, and the steps you will take, culminating in eviction proceedings. It should state that the tenant is liable for all associated costs, including court fees and reasonable attorney's fees if you prevail. This clause gives the document its teeth. In conclusion, creating a property rental contract that works is an exercise in anticipating the what-ifs. It's about translating the routines and potential problems of property rental into clear, unambiguous language that complies with the law. A strong lease protects the tenant by defining their rights and responsibilities, and it protects you, the landlord, by providing a clear, enforceable path for resolving issues. It turns subjective disagreements into objective referrals to a signed document. Don't view it as a mere administrative task. View it as the essential business operating agreement for your rental property. Invest the time to craft it carefully, have it reviewed by a local professional, and you will sleep far easier knowing your investment is shielded by a document designed to handle reality. Disclaimer: I am not a lawyer or licensed legal professional. The information in this video is for educational and informational purposes only. It is not a substitute for professional legal advice. Landlord-tenant laws vary dramatically by state, county, and city and are subject to change. You must have your rental agreement reviewed and approved by a qualified attorney licensed in your jurisdiction before using it with a tenant. This is a critical step to ensure compliance and